Chapter 16, Section 2. It's all about criminal law and how the Constitution of the United States establishes and protects the individual's fundamental rights and liberties. And so you'll see a number of terms today, such as prosecution, crime, penal code, parole, mandatory sentencing, arraignment, testimony, cross-examining, acquittal, and hung jury. So we're going to walk through the process of what a trial looks like. So in addition, you'll see terms like function, confined, sufficient. Again, these are all very technical terms with precise definitions that we'll go over today. The underlying principle with the criminal justice system is to prevent crimes that harm our society. And so that's the purpose of penalties. We know that just because a law is in the books, that does not mean that everyone will follow it. And so we must put penalties in place. And sometimes they are an effective deterrent, sometimes they are not. So in criminal cases, defendants are charged with crimes, and then if they are convicted, they are then sentenced as punishments. We'll look at that process like today. So in a criminal case, the state or the federal government is the plaintiff, like we've learned. They are the accuser charging someone with a crime, and the government serves as the prosecution. And so the prosecution is the party who starts the legal proceedings against another party for violating the law. And so the prosecutor is the one, again, accusing the individual or group of a crime. And the difference between a crime and a civil case is a crime is something that harms the safety of the society. And so our formal definition of a crime is an act, an action that breaks a law and causes harm to society or people in general, or even individuals. So, a crime either breaks a federal or state criminal law, and it may be something that causes harm to people or harm to society in general. Now, the criminal justice system includes all of the courts, all of the police, Henderson County Sheriff's Department, and all of the prisons, including the one here in Henderson County. For minors, there is a separate system. It's called the juvenile justice system. So if you are under the age of 18 and you commit a crime, then you will probably be charged as a minor. Now, if you commit first-degree murder and you are close to the age of 18, you are likely to still be tried as an adult. However, the juvenile justice system is a separate system that works in a more lenient fashion. All of this is based on the penal code. The penal code is a state's written crime laws with punishments. So if you are driving along at a reckless speed and you strike a pedestrian and they die, you are in violation of a number of penal codes. Meaning, A, you shouldn't have been driving recklessly. B, you shouldn't have hit that person. And there are prescribed rules in reference to reckless driving, and there are prescribed consequences, especially if someone dies as a result of your actions. And so the penal code are these written criminal laws in each state. And in most cases, federal and state law are in agreement with one another. For example, murder. You're in violation of both federal and state law. There are laws that are specific to each state. For example, gambling is not illegal federally, yet it is illegal in the state of North Carolina. And so to run a gambling ring out of your house is a violation of the state's penal code. And once more, there are punishments that go along with these. Now, if you ever do wind up in trouble, odds are it will be a misdemeanor. It will be something minor. You may receive a fine, like a traffic ticket. You may be sentenced to jail. But if it is a misdemeanor, you're probably not going to serve a long period of time, probably less than a year, probably really just a few months. Now, I hope that none of you or that no one you know ever get convicted of a felony. A felony are very serious crimes. The student that called in the threat to our school was convicted of a felony. It's a minor felony. He was charged as a minor, so it's not as severe as, say, 10 to 20, but they will serve time. And they could be imprisoned for more than a year. In their case, it was a Class H felony. It's a more minor charge, but they're still going to be serving time. And in extreme cases, such as first-degree murder, that is premeditated in cold blood, the death penalty is still permissible in certain states. Convicted felons lose certain civil rights. Number one, not least of which, you're going to have a hard time finding a job because most applications require you to check whether or not you have ever been convicted of a felony. And most good jobs are going to stop you right there. You may lose the right to vote. You may lose the right to ever own a firearm. You may lose the right to obtain a driver's license. And once more, you may lose the right to ever be employed. If you're a convicted felon, you're not going to become a teacher. I mean, let's be honest. I had to submit to a background check to be in front of you. Had I ever committed a felony, then I wouldn't be here. Misdemeanors, however, often don't go on your permanent record and can be removed within a certain period of years. But sometimes they can be treated as a felony. For example, if you are caught driving under the influence, your first offense would be a misdemeanor, meaning that it can be expunged from your record after a period of time and good behavior. If you are convicted of repeated DUIs, that could then go on your permanent record, and it can be legally treated as a felony, even if you never hurt anyone. Certainly, if you were ever convicted of driving under the influence and that resulted in a fatality, then you are convicted, you are accused formally of vehicular manslaughter. It's as if you meant to hit the person. What are the penalties for these things? Well, the purpose of criminal penalties are to provide punishment so that a criminal must pay for the offense. They are to protect society as a whole because, let's be honest, some people are dangerous and don't need to be in the general public. That's unfortunate, but that's the world we live in, and that is why criminal law exists. Laws and punishments can exist as deterrents and hopefully warn others not to commit these crimes. It's sad that we have to say there will be a consequence if you kill someone, and that consequence may be all that prevents that act from happening. But if that's helpful, it's necessary. Criminal law can also help prepare lawbreakers to re-enter society after prison. Prison once functioned as a hole in the ground that you are thrown in to be removed from society. The purpose of prison today has evolved. Last spring, I met a history teacher who works in a prison. She helps students to obtain their high school diploma or GED equivalency while they're in prison. She has a classroom just like I do, and she works with people who are seeking an education. Prisons can offer certification programs, they can offer jobs training programs, They can offer rehabilitation, even mental health services. Because the hope is that prison is not just a place where you get tattoos, work out, and hopefully not get killed, which unfortunately that's the view that society holds sometimes. Prison is designed to prepare these people for the real world, because ultimately, unless they're serving life with no parole, they're going to be out at some point. And we have to hope that when they get out, they're not just going to become a deadbeat and hurt more people. And so again, prison can serve a rehabilitative purpose. How do you determine a sentence? So assuming that you've been found guilty of a serious crime, it is now up to the judge to set a sentence. And there is a system of indeterminate sentences that has been used in the past. Meaning that a judge has some flexibility. And so if you are ever convicted of a crime, it is in your best interest to be penitent, remorseful, ask for mercy, because the judge does have some flexibility in what he or she may decide to do. Parole can be an option in some cases, meaning that if you get in trouble and are sentenced to jail or prison, good behavior might get you out in less than the time that you were sentenced to. Furthermore, some crimes have mandatory sentencing laws. Mandatory sentencing means that a punishment must be imposed in a certain way, and that the judge has little flexibility in how that is carried out. And this system has its critics. Some have claimed that judges may be forced to impose harsher sentences than are justified, depending on the circumstance of the case. For example, if you are caught with a dealer quantity of marijuana, that could be as little as 3 ounces. It could be as much as 100 pounds. But there is a mandatory sentencing law that, regardless of the excessiveness of the quantity, may put you away for a very long time. And some have argued that's excessive. And once more, the Constitution says that punishment must be proportional to the crime. A lot of states give judges more options, more flexibility, like shock incarceration, intensive supervision, probation, or parole. Meaning you might have the little ankle bracelet that says you have to be at home, you're under house arrest, or you can go to school. And that ankle bracelet has a GPS device and can actually allow you to live your life assuming that you meet certain guidelines. Basically, the judge can ground you without having to send you to prison. An extreme form of this would be house arrest. And so, some laws require mandatory sentencing, some do not. And again, there are critics on both sides. What does the procedure look like? You've now gotten in serious trouble. You've been arrested, you've been Mirandized, you have now been taken into custody. And so criminal cases follow several different steps. We'll start with, oh my gosh, you've gotten arrested. The blue lights are behind you, you've done something. Not just a speeding violation, but you've done something. Your vehicle is now on the side of the road. You're now in the back of the squad car. You have rights. You still have rights. You are entitled to the protection of due process. In fact, you must be made aware of those rights immediately. As soon as they put you into the car, they're going to handcuff you, and they're going to ask you to step in the back of the vehicle. And all that is a prescribed process called due process. Of course, this begins with an arrest. Officers are going to make an arrest when they have either witnessed a suspected crime, meaning they actually saw it happen, or if a citizen has made a complaint or report of a crime. So if you witnessed a crime and notified the police, that is probable cause for them to make an arrest. So if I saw Sophia run over an old lady and hit the gas pedal, that's a crime, obviously. Well, I'm going to report it. I can't chase her down. I'm on foot, so I'm calling on my cell phone. Hey, Sophia just hit an old lady and took off running.
Would you call 911 for that?
Absolutely, you would call 911 for that. And because that's going to get you the quickest response. Because they have squad cars patrolling the general area. They're going to dispatch an officer. He's going to pull her over as soon as he can find her. Of course, the best thing is to give as much information as you can, license plate, description of the car, description of the individual, etc. But those are grounds for an officer making an arrest. In addition, a judge may even issue an arrest warrant. So, for example, perhaps you have been suspected of a crime, and now probable cause has been demonstrated to a judge, and they have now put out a warrant for your arrest. So even though the crime was not witnessed by an individual, the results of an investigation have led to enough of a probable cause for something to be done about it. Arrested. You're caught. Well, now you're going to be booked. Congratulations, you get fingerprinted. You get your picture taken. It's usually not your most flattering picture, but you have to have a picture taken for identification purposes. But you still have rights, even while you're being arrested. They have the right to fingerprint you and photograph you. They have the right to incarcerate you, meaning to hold you in custody. But you still have the right to call a lawyer. Once more, even if you can't afford one, then one is provided for you by the state. And so yes, even if you can't afford one, it's provided for you. Now, a few hours have gone by. You're in some type of holding cell. Unlike the scary movie, The Trial, that we were watching by Franz Kafka, you have the right to be informed of your charges. You have absolutely the right to know what the heck has gotten you into this mess. In fact, the prosecution must show probable cause for believing that you committed the crime. And so someone, a detective or a police officer, is going to come to talk to you to inform you of why you're here if you didn't know already. And you have the right to ask them why you're here. You have the right to cross-examine their accusation. And again, they must show probable cause to demonstrate why they have arrested you. And next, you are within a few hours going to go before a judge, and you may be set free pending a future court date. You may get to go home that same day, even if you've been arrested. Or they may choose to hold you. They may set bail. They may say, okay, you pay X amount of money. You'll get that back when you come to your court date. It depends on the situation. Now, that first hearing before a judge, again, is going to determine the severity of your case. If it is an extremely serious case, then a jury is going to be called up. That means, Michaela's going about her business as a student. Oh, dang. She's called up for jury duty. She's got to go let her teachers know, her employers know, her family. She's going to have to serve jury duty. And so this whole thing, all of you are now called up to jury duty because whatever I've gotten in trouble for is serious enough that I want a jury of my peers to hear the case. Next, the process of information is where enough evidence to bring this to court must be provided. Next, there's going to be an arraignment. An arraignment is a hearing in which a suspect is charged and either pleads guilty or not guilty, in which case the defendant can be formally presented with charges. They enter a plea. If they plead not guilty, the case continues If they plead guilty, the judge issues the sentence and it's over. Now, if a defendant pleads guilty, and this may be part of a plea bargaining agreement, they're convicted, the punishment is determined, case closed. And if they plead no contest, it's basically the same as a guilty. Next, the procedure. The defense lawyer will introduce witnesses. They'll look at case law and gather information. So they're going to do everything they can to try to demonstrate the innocence of the suspect. The defendants have the right to a jury trial if they choose, although some may choose a bench trial, meaning just pleading this case before a judge. If you choose jury, you next select potential jurors. It's like, I don't know, Cameron's kind of sketchy. I don't know if I want her deciding my innocence or my fate. Alan's angry at me for something, so I don't know if I want him involved in deciding the innocence or guilt of my case. And so I can be a part of it. Okay, so I'm going to make my opening statement. My lawyer will, because I'm not that good at it. The prosecution will make their opening statement, and the case begins. In the opening statement, just like in our debate, we're going to lay out the case for why we are right. Witnesses will be called. They will give testimony. Testimony means the statement of a witness that is made under oath. I have the right to cross-examine any witness. Cross-examining means to question whether or not they are telling the truth and to attempt to discredit their claims against me. And then finally, the closing statements. Highlight the testimony, summarize the guilt or innocence of the defense or the prosecution. The judge then explains any laws relating to the case and informs the jury on how to make their decision. The jury will then release a verdict. A spokesperson will be placed in charge of it. Grace is going to do the talking. She's going to lead the discussion. While the jury is conferring, they'll review evidence and arguments. They'll deliberate, and they may do so indefinitely if they choose. But ultimately, they want to get out of there, so they're going to make a decision eventually, and they will vote on that decision on whether or not the defendant is guilty or not guilty. Now, to reach a guilty verdict, evidence must be presented to convince, quote, beyond a reasonable doubt. The verdict must be unanimous, or the person goes free because of a hung jury. A vote of not guilty is legally called an acquittal. A hung jury is when the jury can't make up their mind. If they can't agree on a verdict, once more, it's called a hung jury. You are guilty. The judge or the jury may decide on the sentence, and then again you have the right to appeal.